We've been talking about last night's ruling from a federal judge in Texas revoking the FDA's 23-year-old approval of a key abortion drug and ordering its removal from pharmacy shelves. For more on this, I'm joined by Nancy Northup, the president and CEO of the Center for Reproductive Rights. Nancy, good morning. Thank you for being with us. One of the interesting things about this Judge Kacsmarik's decision last night is that he's put it on hold for 7 days as of last night to give chances for folks to appeal it. The appeal is going to be heard by the Fifth Circuit Court. If you're venue shopping, this is sort of the best outcome for anti-abortion forces, going to Kacsmarik and then getting an appeal to the Fifth Circuit. But tell me what you think might happen, because that's going to have to happen within the next 7 days. We've already heard that the Justice Department will appeal this.
Yes, and let's just start with the fact that the opinion has zero basis in law and fact. You know, as you read it as an attorney, page after page, the judge is just repeating the baseless allegations of the plaintiffs in this manufactured lawsuit, as you talked about, manufactured to get before this judge and also in a conservative circuit. So the Department of Justice has made clear they're going to appeal this. They do appear to be going first to the U.S. Court of Appeals for the Fifth Circuit. And look, if that court does what a court should do, it is going to swiftly reverse this decision. This decision of approving mifepristone for the market over 22 years ago was based on science and fact and studies. And to have one single judge upend our drug approval process that, you know, since the ruling by the FDA to approve mifepristone in 2000, we've had now 22 years of even more safety and health experience. 5 million women in the United States, not to mention the millions around the world safely using mifepristone.
Yeah, it was invented in France, and I think it's been cleared for use there since 1980. So I guess on one hand, I'm thinking the FDA can probably use 22 years worth of evidence to resubmit. But on the other hand, why are we doing this? The judge suggested that the FDA went about it the wrong way. He also made an interesting claim about the folks involved in this case. Kacsmarik says that the anti-abortion doctors who brought the suit forward are more suited to file the suit in the first place on behalf of pregnant women because, in his words, quote, adverse abortion experiences are deeply traumatizing and pose a hindrance to a woman's ability to bring suit. I only bring this up because this is not sort of the logical conversation you and I have, but it's probably useful for America to understand who this judge is and how this judge thinks.
Right. I mean, the plaintiffs in this case, which are anti-abortion doctors and organizations, they have no standing, which in court means that you have some interest that's really at stake beyond a general opinion about something, right? And so here, this should have been thrown out to begin with on standing, not to mention the fact that the underlying claim is wrong. The law and the fact and the evidence supports the approval of mifepristone on the market. But this judge, you know, just on every single objection to this case that the Department of Justice brought, all well-founded. The plaintiffs don't have standing. These claims they bring are barred by time and statute of limitations, you know, 22 years later. Every single one of these, the judge just agrees with the plaintiff. And again, we've talked about they forum shopped. They created the organization that's the plaintiff after Dobbs in Amarillo for the very purpose of getting this judge, which they knew would rule with them. So it is really just shocking that this single judge is upending and threatening access to medication abortion, as you said, in every state in the country.
And as you look at similar cases across the country when it comes to abortion, judges typically use the term fetus. This judge doesn't. This judge uses the term unborn human and unborn child. I almost wonder whether he's setting himself up for an appeal just on the fact that this doesn't seem to be the most sensible of rulings, just the way judges are supposed to rule. This judge seemed to be sort of going farther than the plaintiff's claim even represented.
Yeah, I mean, the judges throughout the opinion, he uses the rhetoric of the anti-abortion rights movement. And so, again, it makes clear what his own personal opinions are on this. And what's really important to remember is that, the American public strongly supports the right to abortion. And we've seen it again and again when they get to decide. So, of course, we saw it in the midterm elections with the big victory in Michigan and also with California and Vermont, all of those states protecting abortion rights. And we saw it in Kansas last summer saying, heck no, don't take our rights away. Kentucky, the same thing. And we just saw it last week in Wisconsin when the voters, by a strong majority, said we do want to have a justice on our highest court in Wisconsin who's going to protect the fundamental right to abortion, to make decisions about our health, lives, and future. So this one judge in this entire coordinated campaign to get a nationwide abortion ban is completely at odds with the views of the American public.
Nancy, thanks for being with us. As always, Nancy Northup is the president and CEO of the Center for Reproductive Rights.